All right, welcome everyone online and welcome everyone here. It's great to have you for another SIPL evening seminar. And today we're really proud to have, an honor to have Emmanuel Oke from the University of Edinburgh, who is going to talk about the Glocal space in international IP law. And I've met Emmanuel first time a couple of years ago in one of the HRIP conferences. We established that earlier on, and Emmanuel has been working on a broad range of international IP topics, but I think also on IP topics, and surely we can sort of discuss that later on. He's been working on public health issues, comparative public health issues, looking at how the right to health features and patent-related decisions in different jurisdictions in developing countries, and he's worked also on international investment law. And I think with that, I'll just hand over to Emmanuel, and you've got whatever number of minutes you need for presenting, and then we'll have some questions. I'll manage the online chat, so you don't have to worry about that. I'll just sort of post these questions to you. So over to Emmanuel, the floor is yours. Thank you.
Thank you very much. Hope everyone can hear me very well. So yes, thank you, Enin. Thank you for the invitation. It's a great privilege to be here. I'm really happy to be here. I look forward to our discussions today. So today, as Enin has mentioned, I will be talking about the local space in international IP law, international intellectual property law. Just to clarify what I mean by that from the start, I think the best place to start is to talk about what I call the local nature of contemporary IP rights. So IP rights, as we all know, can have both local and global connections. An IP right belonging to an individual or a company can be protected contemporaneously in multiple countries at the same time. However, this level and scope of this protection usually tends to vary, right? It's not always similar in all these countries. So that is the local nature of contemporary IP rights as we have them. And that tracks back to the historical development of IP, which was initially territorial, but now we are in what some people will call the global era, but I think there's also a global element to IP rights as a whole. At the same time, the international IP system, I would argue, also has a global component, right? So you have the global space containing mandatory rules. You also have the local space, which is unregulated. And you have what I would call the global space. That's in between this global and local spaces. You have the global space where states can experiment within certain parameters. And I'll explain in detail what I mean by that in the course of this talk. So the focus here will not be on the global nature of contemporary IP rights. I'll be focusing more on the local components in the international IP system. Now, so in terms of the outline of my talk, I'll be looking at three things: localization as an autonomous concept. I'll also look at the global space in international IP system specifically. And then I want to narrow it down by looking at the role of the WTO's appellate body in preserving this global space in international IP law, right? So looking at the dispute settlement system of the WTO there. Let me start by looking at at localization itself, that particular term. What do I mean by that, and why is it relevant in the context of international IP law? I think the starting point is to answer the question, why? So this is an idea I got from sociology, right? So the question is, why is sociology relevant in the context of international IP law or international law in general? And according to Esch in 2015, in his book on sociology and international law, he made the point that employing sociological analysis in international law can be helpful in a number of ways. First of all, it can help to broaden our understanding of the social factors involved in the formation and implementation of international law. It can also provide an interpretative tool for clarifying the content of international legal provisions, right? At the same time, it can suggest better legal mechanisms for coping with new challenges faced by international law. As some of you may be aware, the WTO system, particularly the dispute settlement system, is currently facing a crisis in terms of the appellate body and the appointment of new members into the system. So, and that's one of the reasons why I was interested in looking at the role of that particular body in terms of IP rights and what it has done to either preserve or constrain the policy space available to states, right, under the IP system. Now, so there is a debate the starting point is to look at this debate between sociologists regarding how to define the term localization, especially as it relates to globalization. So there are three main approaches. One approach suggested by Robertson is to see globalization as localization. So I will try and explain what that means. So according to Robertson, globalization should not be seen as homogenization. Rather, it should be seen as localization. So when we say globalization, what we really mean is localization. And that is where globalization is concretized in local forms. The local is influenced by the global. Now, the problem with this approach is that it assumes that there's a mutual relationship between the global and the local. But as we know, there's a possibility of resistance to waves of globalization at the local level. So this framework, I would argue, and it has been pointed out by other scholars, overlooks power relations at the international level, right? So yes, there's a development of globalization and global standards do spread to different places, but there is, at the same time, you have local resistance to some of these global standards and global rules at the national level, right? So his approach, seeing globalization as sort of localization, I think is problematic. A similar framework was developed by Ritzer in 2003, where he views, for his own part, he sees localization as globalization. Now, according to him, localization is the interpenetration of the global and the local, resulting in unique outcomes in different geographical areas. So he makes the point that much of what we see as local should be seen as glocal because almost everything has been touched by globalization, right? The problem with this approach, just as the previous one, is that it sort of erases the local, right? It means it perceives the glocal as an instrument of global capitalism, right? And that is problematic because even though we have globalization, that doesn't render the local irrelevant. The local is still relevant. And that's why I take the approach developed by another sociologist, Brill Nijhoff, who offers a different framework and sees localization as an autonomous concept, right? As distinct from both globalization and localization, right? So he takes the point that it is important to look at the precise manner in which the relationship between the global and the local is shaped. So it draws a distinction between the global, the local, and the glocal, right? And it uses the metaphor of refraction to explain this interface between the global and the local. So it sees globalization now as a process of waves spreading around the globe, right? So we have global standards coming from international institutions or cultural developments in one part of the globe spreading to other parts of the globe. But he uses refraction as a way of explaining how the local relates to these waves of globalization, right? So let me explain what it means by that. Depending on the strength of the local, right, global waves can either be refracted, that is resisted, or reflected at the local level. Right? So it's possible, yes, if you have a new standard, you have a new development, it is reflected and copied 100%. It's also possible to have a refraction where, because of the power that the local has, it can resist those waves coming and say, well, we don't want this, or this is how we are going to adapt these rules or these values in our own system, right? So he uses that concept of, or that metaphor of refraction to explain localization. So according to him, localization is actually what happens when the global becomes refracted instead of being reflected at the local level, right? So under this framework, the local is still relevant, right? You have global standards, but it doesn't erase the local, and it does not overlook power relations between those who are generating these global standards and those who need to accept or resist those global standards. So when there's a level of resistance or there's a form of adaptation of global standards, that is when you have localization under his own approach. So how is this relevant to the international IP system? I would argue that his framework, Brill Nijhoff's framework of seeing localization as an autonomous concept, can be applied in the context of the international IP system. Why? It makes the point that some locales can generate globalizing waves across the globe, across the world stage, because they have the economic power or the political power. And if you look at the history of the TRIPS agreement, we see that developed countries played a huge role in the adoption of the agreements, right? So we can consider them as the source of the global waves of IP protection that we have now. At the same time, he also notes that some locales have the ability to modify or alter globalizing waves, right? And that leads to glocalization. So if you look at, for instance, the example of India, some developing countries have been able to adapt the provisions of TRIPS, at least to an extent, at the national level to suit their local context, right? So I take the view that this glocalization or refraction or resistance, whichever we want to call it, is an integral part of the international IP system because there's a local space in the international IP system itself, right? And I will go on to explain what that local space means now. Now, in terms of the conceptual framework, this is how I think we should think about the international IP system. So I argue that we should think of it as consisting of three spaces: the global space, the local space, and the local space, right? Now, the global space is where you have mandatory rules in international IP treaties, right? The Paris Convention, the TRIPS Agreement, the Berne Convention. And all the mandatory rules you have there are global standards and they make up the global space, right? The local space are the optional rules that we have, flexibilities, limitations, exceptions. And then the local space are aspects of IP that are not regulated by the international IP system. Right? So we have issues like exhaustion of IP rights, image rights, and things like that. Now, we can further distinguish between the international rules and policy space. In terms of the components of the international rules, we can argue that the global space and the local space both make up the international system, right? Because both of these, the elements of these spaces have their origins in the international system, right? But we can draw a distinction between the global and the local. The global is mandatory. States have no freedom at all. They have to implement those standards. But within the local space, they have some freedom that can be used at the local level, right? That is the argument I'm trying to make. At the same time, because the local space has connections with the local, I think it forms part of what I call the policy space, right? So people usually use the term policy space. So I define policy space as consisting of two distinct spaces, the local space and the local space, right? In the local space, you have some freedom. It is regulated, but you still have some freedom, right? You can do certain things. So we have flexibilities, we have exceptions, we have Articles 7 and 8 of TRIPS that allows you, to implement certain measures within certain boundaries, right? So there's freedom here, but it is regulated. This is regulated freedom, right? But in the local space, you have unregulated freedom. You can do whatever you want there because it is not regulated at the international level. So both of these spaces, I would argue, form part of the policy space, or what we usually call policy space. So why is all of this important? I think using the lens of localization can help us to say a number of things. First of all, I think it helps us to see the TRIPS agreement as not an agreement that is aimed at harmonizing IP rules. So that is not the goal of the TRIPS agreement or the international IP system, I would argue. Yes, there are some global rules, there are some global standards in TRIPS, in the Berne Convention, but at the same time, there are elements of the TRIPS agreement that are not aimed at harmonizing the international IP system. So it is this global space that helps to facilitate or foster diversity in the national IP system. And using the global space to adapt global rules should not be conflicted or confused with economic nationalism or protectionism. Why? Because this local space is distinct from the local space. Now, if somebody is doing something based on the local space, you could make the point that, well, that is nationalism or protectionism, economic nationalism now. But because the local space has its origin or foundation in international law or international rules, I would say we can draw a distinction between that and economic nationalism. At the same time, finally, I think localization can be a development strategy for states as it allows them to adapt global rules to suit their local context, as we've seen in the case of a number of developing countries like India and China, right? So how has this space been preserved or constrained by the international dispute settlement system that we have at the WTO? In this regard, I want to focus on the appellate body because of time. We can spend time talking about the panels, but I think I want to focus on the appellate body for a key reason why. Because I think, as we all know, the appellate body is no longer functional. So I think it's a good time to reflect on what they've done in the last 25 years or so in terms of preserving this global space. Now, the global space, because it's regulated, but it also allows you to do some things, it gives you some freedom, is the most contested space in the international IP system. It can be very difficult to define its precise boundaries. However, as I've said, it is regulated, and then that means it can be litigated. So we've had a number of disputes concerning the boundaries of the global space that has been adjudicated by the WTO panels on the appellate body. I'll be focusing on the appellate body. And the key question I want to answer is, as the approach of this appellate body, has it constrained or preserved the global space in the international IP system? So why am I focusing on the appellate body? So scholars have noted that the appellate body plays a role in protecting non-trade values such as health and the environment in the WTO system. And it does this through a number of measures, including using the exceptions in WTO treaties. Gervais has also recently argued that there's been what he calls a pluralist shift in the jurisprudence of the appellate body, where they've sort of fostered competition or interaction between trade law and other norms of international law, right? Now, this is not to say, however, that the appellate body is perfect or that it always protects non-trade norms. In fact, until recently, as Enin has also shown in his previous work, the appellate body panels and the appellate body typically adopt a literal and restrictive approach to interpreting the terms of the TRIPS agreement, and they often overlooked Articles 7 and 8 of the TRIPS agreement. Nevertheless, I think one can make the point that the jurisprudence of both the panel and the appellate body has evolved over time. And then the point has been made, particularly in the context of the current dysfunctional nature of the appellate body, that developing countries are actually better off with a functional appellate body. So these are the reasons why I'm focusing on the appellate body for the purpose of this talk, right? So if you look at the appellate body in terms of IP disputes, they've dealt with 4 key disputes in the last 25 years or so of its existence. So the first one is the India patent protection case, which was decided by the appellate body in 1997. The second one is the Canada patent term case of 2000. The third one is the US Appropriations Act case of 2002. And then, of course, the popular one, the Australia plain packaging case of 2020, right? The last 2 cases deal with trademarks, international trademark law. So in these disputes, the appellate body has made a number of key pronouncements on specific issues, including legitimate expectations, Articles 7 and 8 of TRIPS, and international trademark law. In fact, they've actually said more about international trademark law than other areas of international IP law. So they've dealt with registration and ownership of trademarks, the right of trademark owners, and tobacco plain packaging. So, but let's talk about legitimate expectations, right? I think which is an overlooked aspect of the jurisprudence of the WTO's appellate body in this area. So in the India patent protection case, one of the things that came up was the approach or the conclusion that the panel reached in that case that, well, the concept of legitimate expectations of WTO members must be taken into account when interpreting TRIPS. That was what the panel said. According to the panel in that case, the protection of legitimate expectations is central to creating security and predictability in the multilateral trading system. So they noted that the protection of this concept of legitimate expectations regarding the conditions of competition is a well-established GATT principle. This was questioned on appeal by India in this case. Unfortunately, the appellate body disagreed with the panel's conclusion on this issue. They noted that the panel had incorrectly applied Article 31 of the Vienna Convention. The appellate body further warned against reading into a treaty words or concepts that are not there, right? So according to the appellate body, the legitimate expectations of parties to a treaty are reflected in the language of the treaty itself. So according to the appellate body, the legitimate expectations of the parties to the TRIPS agreement are already expressed in the text of the agreement itself. So why is this important? I'll tell you why this is important now, because according to the appellate body in this case, what the panel did in this case was to conflate or combine two different bases of action, violation complaints and non-violation complaints under Article 23 of GATT into one course of action. So, and the appellate body noted that this is inconsistent with both the GATT agreement and Article 64 of TRIPS, and the issue of non-violation complaints is not something that should be resolved through interpretation. It's something that it is for the TRIPS Council to resolve, according to Article 64. And it's interesting to note that even though this decision was made in 1997, till date, the TRIPS Council has still not adopted any decision on this issue. It still remains unresolved, and developing countries are still opposed to the application of non-violation complaints to TRIPS, right? So, but if the appellate body had not intervened on that point, the point, it has been said that the approach of the panel would have indirectly opened the door for non-violation complaints in the context of TRIPS, and it will be disguised as violations of the concept of legitimate expectation. So I think what the appellate body did in that case, one of the first cases they dealt with on IP was very good in closing the door to using the dispute resolution system to read into TRIPS what is not in TRIPS, right? So, but I think that was very important. Then coming to Articles 7 and 8 of TRIPS, as I've said before, and as Enin also pointed out in his previous work, prior to the Australian plain packaging case, most of the panels and even the appellate body avoided trying to explain or clarifying the role of Articles 7 and 8 in the interpretation and implementation of TRIPS, right? So, but in this Australian plain packaging case, both the panel and the appellate body actually went out of their way to specifically elaborate on the role of both of these provisions. And as I assume the audience knows, Articles 7 and 8 deals with the objectives and principles of a TRIPS agreement, right? So, and according to Article 31 of the Vienna Convention, both of those provisions are relevant to the interpretation of the text of the TRIPS agreement. So in the Australian plain packaging case, the panel noted that Article 8 provides useful contextual guidance for the interpretation of the TRIPS agreement, particularly the term unjustifiably in Article 20. Interestingly, on appeal to the appellate body, one of the complainants in that case, one of the appellants or jurors, claimed that only matters linked to trademarks, such as, for instance, the potentially misleading nature of trademarks, should trigger an encumbrance on the use of a trademark. The appellate body disagreed with this, and he said that and he agreed with the panel that encumbrances can be imposed for other reasons besides issues linked to trademarks. So for instance, they can impose encumbrances on the use of trademarks in pursuit of public health objectives. And I think one of the interesting things that the appellate body, did in this case was to also cite Article 8 and to go ahead and say that, well, measures seeking to protect public health and nutrition can cover a range of measures. So they went beyond Article 20, right? They cited a number of other exceptions in the TRIPS agreement, like Article 30, Article 31, Article 39.3, to say that, well, you can use Article 8 to justify the use of these exceptions if you want to do that. So I think the appellate body's approach in this case highlights the importance of Article 8, not just to the interpretation and implementation of Article 20, but other provisions that can affect public health in the TRIPS agreement. So I think they've gone further than they've done before. I mean, they could have done more in this case, but I think they've gone beyond what they've done in the past. So moving to the issue of international trademark law specifically now, if you look at the jurisprudence of the appellate body, as I've said, they've spent a lot of time talking about trademarks more than other types of IP rights. In the US Appropriations Act case, citing Article 6.1 of the Paris Convention, the appellate body said that WTO members have the right to determine the conditions of filing and registration of trademarks. So as long as all the other requirements in the Paris Convention and TRIPS are met, states are free to impose additional conditions for the registration of trademarks, right? So in this case, they also confirmed that even though, yes, Article 16.1 of TRIPS gives trademark owners exclusive rights, Article 16.1 does not specify how ownership is to be determined. So, and they made the point that the drafters of the Paris Convention did not intend to establish a global system for determining trademark ownership. So it agreed with the panel in this case that the definition of the conditions of ownership of trademarks is within the discretion of states. Again, I think this approach confirms the freedom or the glocal space that states have in this area. So in terms of imposing additional conditions for registering trademarks or defining who the owner of the trademark is, because those issues are not dealt with in the TRIPS agreement. So as long as you comply with the other requirements in the Paris Convention and the TRIPS agreements, you can do whatever else you want in this area. And on the issue of the rights of trademark owners, again, I think the approach of both the panel and the appellate body in this case, in the Australian plain packaging case, is commendable because they confirmed that the rights conferred on trademark owners under Article 16.1 is only a negative right to exclude third parties, but a positive right to use. I mean, again, this confirms previous rulings by other panels, but the implication, I think, is important. It means states can implement measures that may affect the use or distinctiveness of trademarks as long as there's compliance with other TRIPS requirements like Article 20. And that takes me to Article 20 itself. Article 20 provides that the use of a trademark in the course of trade should not be unjustifiably encumbered by special requirements. Now, this implies that states can encumber the use of trademarks as long as it is justifiable. Now, what the appellate body did differently was to say that, well, unlike the panel came up with this three-factor test that it was trying to use to assess whether or not a measure is justifiable. The appellate body in this case clarified that in determining whether or not a measure is justifiable, it is unnecessary to apply a rigid and exact set of factors. So the most important thing is to be able to show that the measure is justifiable, and they define that as being able to supply a reason that sufficiently supports the encumbrance, right? So instead of applying the three factors developed by the appellate body clarified that it's not that restrictive. You can apply a simple standard. They also clarified a number of other issues. They said it's not necessary to consider alternative measures under Article 20, and they rejected the attempt to import a necessity test into Article 20, which will have required encumbrances to be necessary in order to be justifiable. So I think, again, the approach of the appellate body, and this was the last case that the appellate body dealt with in terms of international IP law. I think the approach here is consistent with their previous approaches of preserving the regulatory autonomy, or what I call the global space of states under international IP law. So in conclusion, as I said, I think there is a global space in international IP law. I think we should distinguish between this space and the global and local spaces. We should draw a distinction between those two spaces. The global space exists to foster diversity and enable states to calibrate the rules of international IP law to suit their local needs. And I think despite its flaws, it's not a perfect system. I think the appellate body has actually shown that it can play a key role in preserving this global space. And I think for me, the most important thing is to emphasize the fact that this local space is important for developing countries because localization can be a development strategy for them to move and adapt rules, international rules, to suit their local context. Thank you very much.